Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya. In today's interesting episode of Polity Primer, we are going to talk about yet another important and significant constitutional amendment acts which talked about the welfare of the scheduled castes and the scheduled tribes in India. The title of our today's discussion is the 65th and 89th Constitutional Amendment Acts. In this discussion, we are firstly going to study about what is the 65th Constitutional Amendment. We are also going to examine its historical background. Then we are also going to talk about the Article 338 of our Indian Constitution. We are also going to examine the constitutional changes that has been introduced in our Indian Constitution by way of 65th Constitutional Amendment Act. Then we are also going to talk about the National Commission for Scheduled Castes. We are also going to have a look at the 89th Constitutional Amendment Act, and we'll finally be talking about the National Commission for Scheduled Tribes. And lastly, we are going to discuss some of the important questions that are important from the perspective of your prelims examination. So if I talk about the 65th Constitutional Amendment Act, see, welfare of the scheduled castes and scheduled tribes has been provided under various articles of our Indian Constitution. So what used to happen before this amendment was, there was a special officer whose work was the welfare of the scheduled castes and scheduled tribes community in India. But this office of the special officer for the welfare of the scheduled castes and scheduled tribes was abolished by the 65th Constitutional Amendment Act, and finally we had a constitutional body, that is the National Commission of Scheduled Castes and Scheduled Tribes. So when the 65th Constitutional Amendment Act was enacted, it was just one commission, okay? It was bifurcated later on, and we will be studying about it in our further slides. But when the 65th Constitutional Amendment Act was passed, we had this just one commission that was responsible for the welfare of the scheduled caste and the scheduled tribes of India. And for this purpose, Article 338 was amended. Now let us discuss the historical background behind the enactment of this 65th Constitutional Amendment Act. So as I was explaining to you before, there was a special officer, also known as the commissioner, who was responsible for the welfare of the scheduled castes and the scheduled tribes communities in India. So in the year 1978, this office was also existent, and the government of India, by way of a resolution, established the non-statutory commission, which was a multi-membered commission for the welfare of the scheduled castes and the scheduled tribes of India. And in the year 1987, it was finally named as the National Commission of SCs and STs, and it was a combined commission. So this prompted the government to think about the welfare of the scheduled castes and the scheduled tribes of India, because the need was felt that yes, they are entitled to their constitutional rights, and we need a separate body specifically working for their welfare and ensuring that they enjoy their constitutional rights. Moving forward, let us discuss Article 338 of our Indian Constitution. So the present day Article 338 of our Indian Constitution deals with the National Commission for Scheduled Castes. Okay, it provides for the composition of the commission, its duties, appointment of members, and other powers of the commission. So basically the commission is responsible for the following functions: to collect an information and monitor the implementation of constitutional rights, constitutional and legal both, legal rights of the scheduled caste community. Okay, then it also provides for the function of the NCSC, also entails within itself to submit a report to the president regarding the welfare of the scheduled caste community. It also examines the complaints which includes the violation of constitutional and legal rights of the scheduled caste communities. It also works for their socio-economic development. And it also makes recommendations to the union government and state governments. Makes recommendations to the central government and state governments. And the central government and the state governments are duty bound to pay heed to the recommendations made by the NCSC. Moving forward, let us examine the constitutional changes that have been brought by the 65th constitutional amendment in our Indian constitution. So, Article 338 has been amended to provide for the appointment of a commission consisting of a chairperson, vice chairperson and 5 other members. Subject to any law made by the parliament, the conditions of service and tenure or office of these persons will be determined by rules made by the President of India. So basically, it changed the composition of the commission from single-membered body to a multi-membered body. Multi-membered body. So this was the major change that was brought in Article 338 of our Indian Constitution via the 65th Constitutional Amendment Act. Moving forward, let us examine the National Commission for the Scheduled Caste. So the separate National Commission for the SCs came into existence in the year 2004. It consists of a chairperson, a vice chairperson and 3 other members, and it is a multi-membered body as has been prescribed by the 65th Constitutional Amendment Act. They are appointed by the President under by his warrant under his hand and seal, and their conditions of service and tenure or office are also determined by the President. And we have discussed the important functions of NCSCs in our previous slides. Okay, moving forward. The Commission presents an annual report to the President of India, and this is very important for the Commission to present an annual report regarding the welfare schemes for the scheduled caste communities and whatever is happening in the country regarding them. If there are any complaints against the harassment of these communities, what can we do to make them so more developed socially and economically? So all of this is present in the report that is submitted by the NCSC to the President. It can also submit a report as and when it thinks necessary. So complete autonomy has been given to the NCSC to submit its report to the President of India. The President places all such reports before the Parliament along with a memorandum explaining the action taken on the recommendations made by the Commission. And if the government is not taking any action on the recommendations made by the NCSC, Then the memorandum also will contain the reasons. That means it has to be a reasoned decision. The government will have to give reasons behind the non-consideration of the recommendations of the NCSC. Finally, this report is also provided to the governor of states, and he places this report in the houses of the state legislative assembly. Okay, so the process is similar for the union government and the state governments, and they are duty bound to have a consideration of the recommendations of the NCSC. Moving forward, the commission is vested with the power to regulate its own procedure. So it is completely an autonomous body. It is not coming under any other body. So it has complete autonomy over taking its decision, regulating its own procedure, etc. And the commission, while investigating any matter or inquiring into any complaint, has all the powers of a civil court trying a suit. Especially if you talk about summoning of witnesses, hearing them out, and conducting the civil trial in a civil suit. So it is empowered to do all of this, and it is also empowered to inspect any documents if there is a complaint. So basically it has all the powers of a civil suit, civil court which is trying a civil suit. Moving forward to the 89th Constitutional Amendment Act. So what was the purpose behind the enactment of the 89th Constitutional Amendment Act? So basically it was realized that the scheduled castes and the scheduled tribes are very different from each other. And that is why a separate ministry was also formed for the welfare of the scheduled tribes. And this ministry is known as the Ministry of Tribal Affairs, and it was formed in the year 1999. So basically the need was felt that yes, we should have a separate commission that is dedicated to the welfare of the scheduled tribes in the India. So the 89th Constitutional Amendment Act of 2003 again amended Article 338 of our Indian Constitution. And what was the need? Because I have explained that these two bodies were not different previously. Okay, they were the same body, and that body was known as the National Commission for Scheduled Castes and Scheduled Tribes. So by the 89th Constitutional Amendment Act, this joint body was separated. It was bifurcated into the National Commission for Scheduled Castes and the National Commission for Scheduled Tribes, and a new article, that is Article 338 Clause A, was added to our Indian Constitution. Moving forward, let us study about this National Commission for Scheduled Tribes. So the separate National Commission for Scheduled Tribes came into existence in 2004. And it consists of a chairperson, a vice chairperson, and 3 other members. So basically the composition of this commission is similar to the NCSC. They are appointed by the president by warrant under his hand and seal, and the conditions of service and tenure or office are also determined by the President of India. Moving forward to the functions of the commissions. So basically to investigate and monitor all matters related to the constitutional and other legal safeguards for the STs, and to evaluate their working, to inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled tribes communities in India, to participate and advise on the planning process of the socio-economic development of the STs, and to evaluate the progress of their development under the union or a state. So as you can see, it performs a very similar function to the NCSC. Moving forward, to present to the President annually and at such other times as it may deem fit, reports upon the working of those safeguards which are given to the scheduled tribes community in India, to make recommendations as to the measures that should be taken by the union or a state for the effective implementation of those safeguards, and other measures for the protection, welfare, and socio-economic development of the scheduled tribes community in India. So these are the basic functions that are being performed by the National Commission for the Scheduled Tribes. Moving forward. To discharge such other functions in relation to the protection, welfare and development and advancement of the STs as the President may specify. And the Honorable President of India specified this other functions in the year 2005 by way of a legislation. By way of a legislation. And these other functions include that, yes, they are given the minor produce of the forest surrounding which they are living. Okay, they are supposed to be given livelihoods. They are supposed to be given their special rights over the water management, forest management, etc. So all of these other functions was specified by our Honorable President of India in the year 2005. Moving forward. As the NCSC, so is the NCST also submits its report to the President of India, and that report has to be considered by the union government and state governments. Moving forward. With this, we come to a conclusion of our today's discussion. We have seen what was the 65th Constitutional Amendment Act. We have also seen that what steps it took to have the welfare of the scheduled castes and the scheduled tribes community in India. We also examined the 89th Constitutional Amendment Act, and we have also seen the National Commission for Scheduled Castes and Scheduled Tribes. Now, let us discuss the practice question which I asked you in my previous session. So, the question was, which of the following changes was not introduced by the 44th Amendment Act of India? So, your option A was empowering the Supreme Court to withdraw cases from High Courts either suo motu or upon a party's application. Your option B was repealing the provision for appointing distinguished juries as High Court judges. Your option C was curtailing High Court's original jurisdiction regarding revenue matters. And your option D was introducing Article 139 Clause A, allowing the Supreme Court to withdraw cases from High Courts upon the Attorney General's application. So your correct answer is going to be option D, introducing Article 139 Clause A. Now let us discuss the practice questions from our today's session. So the question is, consider the following statements. Your statement number 1 is, in order to safeguard the interests of the STs more effectively, it was proposed to set up a separate National Commission for STs by bifurcating the existing combined national commissions for SCs and STs. And this was done by passing the 89th Constitutional Amendment Act of 2003. Which of the statements given above is our correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is none of the above. So your correct answer is going to be option C. Both 1 and 2 statements are correct. Now let us discuss another question from our today's discussion. So the question is, consider the following statements. Your statement number 1 is, the separate National Commission for STs came into existence in 1999. Your statement number 2 is consists of a chairperson, a vice chairperson and 3 other members. So which of these statements given above is our correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is none of the above. So your correct answer is going to be option 2, statement number 2 only. Now let us discuss the last question of our today's discussion. So the question is, consider the following statements. Your statement number 1 is, the National Commission for SCs and STs came into being consequent upon the passing of the 65th Constitutional Amendment Act of 1990. Your statement number 2 is, the commission was established under Article 338 of the Constitution with the objective of monitoring all the safeguards provided for the SCs and STs under the Constitution or other laws. So which of the following statements given above is our correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is none of the above. And this answer will be given by you to me in the comment box below. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.